So now we need to understand what are the essentials of a valid contract, because we can't just get a piece of paper, have everything and say this is a contract and this is a valid contract. There are definitely some essentials that we need to incorporate into it for it to become a valid contract. Okay, so now we'll see what are the essentials of a valid contract. Coming to the essentials of valid contract, there are few essentials which are specifically given by section 10 of the Indian Contract Act. When you say essentials, just recollect section 10. Essentials, section 10. There are few essentials given by this, and there are few essential of a valid contract which are not given by section 10, but then it's really important for us to include all those in our contracts. So without including these into our contracts, we can't say that this is a proper valid contract. You can't just go by section 10 and say we have all this, we have agreement, free consent and all this, and this is a contract. No, that doesn't work. We need to also consider the other essentials which are not given by section 10. Okay, as soon as you hear the word essentials of a valid contract, just recollect section 10, and you will have to recollect there are few essentials given by section 10 and there are other essentials apart from what are given by section 10. Let us first see the essentials which are not given by section 10. Okay, section 10, because the law clearly explains everything in the section 10, but it's really important for us to understand something which is not given by law. So we'll see two parties. Law did not include this term two parties in it. So it's important for us to understand, because we can't just, a single party can't make a contract to himself. It's really important. Though this may be sound like a silly point, but it's really important. There should be a two parties. The one party cannot have a contract with himself. Okay, that's one thing. And here, I think these have come from the case laws that we have got. Okay, so though a section did not stipulate this has come from various case laws. If you read further here, under two parties, there is one case law. It really helps if you can recollect this case law and write in the examination. Okay, there's one case law which is this Gujarat versus Ramanlal S and Co. This case law supports our essential two parties. This says how important it is to have two parties in a contract. If you read through this case law, this Gujarat versus Ramanlal S and Co, it's pretty simple. This Ramanlal S and Co is a partnership firm. Upon the dissolution of the partnership firm is nothing but they are putting an end to this firm. Okay, while leaving the firm, definitely firm will have some assets, right? The question is who would be taking these assets? Obviously, the very partner themselves take away these assets when they are closing down a firm. So now this case law says that partnership firm Ramanlal S and Co cannot have agreement with its partners saying that upon ending this firm, all the assets of this partnership firm will be given to partners. Here, if you really look into the context, just the same party. Partnership has got partners, and again, the agreement is being made with the same partners. Looks like there's just one single party over here. Law doesn't permit these kind of agreements. I mean, these are not enforceable as such. Partners cannot sue the partnership firm when, upon the end of the firm, when there are no assets being given to them, because this is not a valid contract as per Indian Contract Act. Indian Contract Act always wants two parties. Here, if you see, partnership firm has got partners, and again the same partners are making agreement to contract with themselves. That doesn't work. So you can just quote this example when you give. When there's an answer saying that what are the essentials of law, they might be giving you a case law. In that case, you'll have to. Well, I guess this two parties definition, you'll have to quote this Gujarat versus Ramanlal S and Co case law. That really helps to elaborate that particular answer. Okay, one cannot contract with himself. A contract involves at least two parties. Okay, at least two parties, and parties need not always be a natural person, need not always be a human being. That other party can be a contract. A person can make a contract with a company. Suppose A can make a contract with, say, Infosys. Okay, Infosys is a company, but it is a company. When registered, it becomes a legal person. A is a natural person, company is a legal person. contract can be done this way. Okay, but with partnership firm, we can't consider that partnership firm to be a legal person, so partnership firm can't make agreement contracts with its partners. Okay, got it? So two parties, because one cannot contract with himself, that you would be writing, and then you'll say at least two parties, one party making the offer and the other party are accepting it. So that is the two parties, which is the first most essential thing that a contract should have. And then after there are two parties, well, what do the two parties do? They must have to create a legal obligation. As I mean, I've been continuously repeating, social obligations are not enforceable under the Indian Contract Act. These two parties must intend to create a legal obligation. There should be a contract is not a silly thing that we do. There should be really an intention on the both the parties to create a legal relationship. Legal relationship is nothing but I mean, again, in the business context, A selling, I mean, the very same old example, A selling goods to B. So there they must be able to create a legal obligation, goods and money. Okay, fine. And again, as I told you, social or domestic type of agreements are not enforceable in as per our Indian Contract Act. If you see social agreements, again, there's the example that which I've told you, that is an A husband agreed to pay his wife certain amount of maintenance and failed to pay. This is again this Balfour versus Balfour case law. If you could quote this when giving this essential, parties must intend to create legal obligation, that really adds to your answer. You can quote this Balfour versus Balfour saying that husband agreed to pay maintenance but failed to pay. Wife sued him for the recovery, but it is a social agreement, so we did not create any legal obligation, that is not enforceable by law. So we have seen the what is the first essential that we have covered, two parties, and the second essential is the legal obligation. And remember, all these essentials are coming from the case laws but not from section 10 of the Indian Contract Act. Section 10 gives us other essentials which we will be covering later. Now, we're done with two essentials which are not given by section 10. Now the third essential is other formalities to be complied with in certain cases. There are certain formalities. For example, here you see they've quoted as an example of the insurance. An insurance contract is not valid unless it is a written contract. So when there are these type of essentials, unless these type of validities or essentials are complied with, it cannot be a contract. Fine, that is really important for us to cover a contract. And then uh, two examples here you can quote while saying other formalities to be compliant with in certain cases is, first example you'll write saying that contract of insurance is not valid except as a written contract. And the second essential is if you buy or immovable property or sell an immovable property, it is not enforceable until it is registered. Okay, these type of other formalities which are given by other laws also should be complied with for that to be a proper contract. Okay, and then you'll have to see the certainty of the meaning. Agreement must be certain and not vague or indefinite. Certainty of meaning, by certainty of meaning, it means that when you are doing an agreement, if you say A is selling goods, is a very vague term, vague or indefinite term. You can't just get into an agreement saying that A will sell goods to B and B will give 2 lakhs. Okay, here you should specify what these goods are. What is this? Is it books, or is it? If you see the pharma industry, it may include some type of chemicals or whatever. It should clearly specify what that particular good is. Only then we can say that there's a certainty of meaning into it, and that is one of the essential. So two parties, and they must have an intent of creating legal obligations. And third one is, if there are any other formalities like insurance contract should definitely be a written contract, and the case of sale or purchase of immovable property, that particular contract should be registered. These kind of other formalities should be fulfilled, and there should be certainty in the meaning. Certainty in the meaning is nothing but, as I mentioned, there should you can't just say goods because the term is very vague. Even you take an example of oil, you cannot enter a contract saying that A sells oil to B. You should specifically mention what kind of oil it is. cooking oil, groundnut oil. There should be certainty into it. Only then you can say that uh, this is one of the essentials of contract. And then the fifth element, which is not given by section 10, is possibility of performance of an agreement. There should be possibility. You cannot say an agreement to be uh, as we have an example over here. A agrees with B to discard treasure by magic. Do you think that's really possible? No. There should definitely be possibility of performance when there is an contract or agreement is being happening. Okay. So quickly recollect what are the five essentials. As I told you, essentials of a valid contract are given by section 10, and there are also few essentials which are not given by section 10. It's important to understand which is given by our contract and which is not. Not given by section 10 is parties, and there should be intention of legal obligation to both the parties. Social obligations are not covered, so there should be intention of legal obligations. And then we saw there should be certainty, and if there are any formalities that needs to be covered, like we said, insurance contract is enforceable only when it is written, and sale or purchase of a movable property or a house property, that should have a sale deed to be registered. And then there should be possibility of performance. There should be possibility. So these are the five essentials that are to be incorporated for it to be a valid contract. Okay. And then there are others which are given by section 10 of the act. Section 10 of the act, we learn those.